and it's now time for Constitutionally Speaking. That very interesting segment that we do every Tuesday morning at 8:05. And we are, in fact, in partnership with our friends of the Office of the Public Defender. And I'm very excited about this morning's feature because as I've been telling you, there is a situation where there was a ruling on the 6th of May in the Supreme Court here in Jamaica, ruling that was handed down to the effect of which was to disable one of the tools used by the current government in its crime-fighting efforts. The ruling was that the states of emergency declared between the 18th of January 2018 and the 15th of February 2023 were, in fact, unconstitutional. This, to me, is a major development, and so we're very, very pleased that the Deputy Public Defender, Mr. Herbert McKenzie, well-known attorney at law, has all the facts and will be able to share them with us this morning. Welcome back, Mr. Mack. How are you today?
Thank you very much. I'm well, and you?
I'm doing well myself. And
good.
I hope it shows in my voice because I'm really excited about this morning's feature. I want you, if you will, to start by taking us to how this case all started in the first instance.
All right. Let us go a little before the case itself started, because that is what triggered the starting of the case. The government had passed several states. The government had declared several states of emergency in different areas of the island.
Yes.
Now, under the law, the initial duration of the states of emergency is 14 days. Thereafter, to continue it or to extend it, there must be parliamentary approval. And with parliamentary approval, it would require one member of the opposition from the Senate to vote with a ruling party. Now, the PNP opposition kept saying, and in fact they vacillated because on some of these extent that they voted for it, but they kept saying that the state of emergency as is being used or was being used by the government was unconstitutional. So now to the start of the case, PNP functionary Dr.
Dayton Campbell,
yes, who's the General Secretary of the PNP, commenced the proceedings in the Supreme Court to test the constitutionality of the case. Now, a lot of arguments were deployed by his lawyer and by the lawyer against him, which is the government of Jamaica's legal advisor, the Attorney General. And the Court of Appeal heard everything. And all those arguments confronted or posed before the Supreme Court quite a number of issues which the Supreme Court had to grapple with. I want to start by setting out in some form the issues which the court had to deal with in coming to this decision.
Yes.
The first issue was whether or not the claimant, the same Dr. Dayton Campbell, he brought the case, so they call him the claimant. In some jurisdiction, they call him the plaintiff. What is Dayton Campbell? Whether or not he has standing, and I'll come back to that. The next issue was whether or not the declarations of those states of emergency were made for the purpose set out in the Constitution. The third issue was whether the declarations were demonstrably justifiable in free and democratic society. And the fourth issue was whether or not the proclamation breached the doctrine of the separation of powers. Now, let us start with the first issue, whether or not Dayton Campbell had standing. Now, standing is a term used to describe the right of an individual to bring an action or to start a case in court, or to appear in court and having that right to be heard. The lawyers have this Latin name they used to describe it as the locus standi. Simple language is standing. On the first issue, the government side took the view that Dayton Campbell had no locus standi, had no locus standing to bring the case. And Dayton Campbell's lawyer responded by resorting to Section 20 of the Constitution. Now, Section 20 of the Constitution is contained in Chapter 3 Chapter 3 is the one which was amended in 2011 to give us reiterate and add to the fundamental rights and freedom. You'll hear people come and refer to it as a Charter of Fundamental Rights and Freedom.
Yes.
Well, prior to that amendment, Dayton Campbell wouldn't have had, or more than likely would not have had standing to bring the case. But that amendment introduced a new section in the Constitution, and the new section effectively broadened the right to bring actions like the one started by Dayton Campbell. In other words, prior to that amendment, the person seeking to bring the action would have to show that he was personally affected by the government's movement, the government's implementation, and that it affected him in a way that caused him to be adversely troubled, or his constitutional right to be breached. No, the new provision says no, that's not the only way. Anybody who is a citizen of the country, anybody who believes that the Constitution or the proclamation of it could have had or would have had adverse rights to other people or in any way breach the Constitution can bring a matter to court to test the constitutionality of the government action. That point was argued full-blown in the Supreme Court, and the Supreme Court held that the new provision in the amendment gives Mr. Dayton Campbell the right to bring the case, because as a citizen, he had the standing and he had sufficient interest in upholding the Constitution and the rule of law, and therefore that point was ruled in the favor of Dayton Campbell. He has standing, he could bring the action. So apart from Dayton Campbell, anybody else, not just those persons who were detained in curfews, in states of emergency, or detained in sweep-up operation, but anybody else, once the Constitution is regarded to have been breached or about to be breached, any citizen can bring the action to test the constitutionality. So on that one, Mr. Dayton Campbell prevailed. The second issue the court had to grapple with was whether the declarations of the states of emergency were made for the purpose set out in the Constitution. And again, the Constitution I'm referring to section chapter 3, which contains the section regarding the proclamation. And under that provision of the Constitution, the purposes are set out clearly. Now, one of the purposes are the purpose under which the government purported to declare the states of emergency.
Yes.
Was in the government's view that there was action taken or immediately threatened by any person or body of persons which is so extensive on a scale that is likely to endanger public safety or to deprive community of any substantial portion of the community of the supplies, services, and essentials of life. In short, the government view was that the state of affairs, as far as the criminality was concerned, was such that it would affect safety, public safety, in the communities in which they were declared, or in the geographical areas in which the states of emergency were declared, and would deprive the community of the essential services for life. And that is the thrust on which the government went into these declarations. Now, Mr. Dayton Campbell and his lawyer attacked that in the court on the basis that the way the states of emergency were declared did not comport with that particular purpose, because there was no immediacy of any threat. And how the court reasoned it out was that the states of emergency, as they came about, really was to address a long-standing problem that the law enforcement was having in curtailing crime. And it was not an immediate situation which sought to threaten life and property. So the court felt, in its reasoning, that that purpose did not satisfy the provisions of the Constitution. And in its reasoning, the court placed some emphasis on the term immediately. Because according to the court, based upon the evidence that was presented before it, there was no immediacy in it. And based on the statistics that was presented in evidence as to the purported reduction of crime, those statistics, according to the court, were not borne out with respect to the period over which the states of emergency were declared, which Nathan Campbell challenged in court. And even though those statistics were found to be true, the court felt that they didn't apply to the periods under consideration.
That would be from January 2018 to February 2023.
23, that's
okay.
Correct.
Mm-hmm.
And the court, why they did not disregard it, they treated it that way because they were considering those states of emergency under the period you just mentioned. And in the final analysis, the court found that insofar as the purpose is concerned, the proclamation by the Governor General acting upon the advice of Cabinet and the Prime Minister was not in line with any of the purposes listed in the Act for which a state of emergency can be lawfully declared.
Mm-hmm.
Now, I have two more issues to deal with. I don't think time is going to allow us to get through all the other two issues, but I'm going to start with the third one, which is whether the declarations of the states of emergency were demonstrably justifiable in a free and democratic society. That amendment which brought in the Chapter 3 had in it some modern provisions. And one of the modern provisions that they imported was to indicate that although the Constitution guaranteed rights, there are certain rights that can be abrogated lawfully by the government. But it must be shown that the abrogation of those rights must be demonstrably justifiable in a free and democratic society. And now, the state of emergency, I don't think it needs a lawyer to know that two of the primary rights abrogated by the states of emergency were, one, the right to freedom of movement anywhere in Jamaica, and your right to liberty. Because we know that the state of emergency prevents people from moving in and around without being questioned, without being stopped at checkpoints. And I'm just saying this not by way of criticism, but by way of observation of facts. And also, the state of emergency included the taking up or the arrest or detention of several persons, and in some cases for protracted period. Now, the court took the view that it can only be demonstrably justifiable if the purpose for which the state of emergency was declared was a purpose that fits into any of the purposes under the law. And since they have found what that is, that the purpose for which the states were declared were not within the law, then it could not be demonstrably justifiable. I'm going to stop here because I see the turn of the clock is weighing heavily upon us.
Yeah.
And next week, I'm going to pick up on this second issue and then go on to bring upon the third issue and then go on to the fourth issue, which has to do with the separation of powers, which is quite an interesting piece.
Yes, and I'm anxious to hear about the implications because If for that period of time, all of those persons who were arrested, is it a case where their rights were breached? And what are the overall implications of this ruling for those persons? All of that, I'm sure, that will come out in our conversation next week. Is that correct?
That is indeed correct, because that has now become quite a topical issue.
Yes.
So until then, more and on.
We look forward to next week when we have you once again Tuesday morning at 8:05 for Constitutionally Speaking. Thank you, Mr. McKenzie, and you have a great day today.